This audio case is brought to you by Laudio. Ex parte McCardle. Decided April 12, 1869. The appellate jurisdiction of this court is conferred by the Constitution and not derived from acts of Congress, but is conferred with such exceptions and under such regulations as Congress may make, and therefore acts of Congress affirming such jurisdiction have always been construed as accepting from it all cases not expressly described and provided for. When, therefore, Congress enacts that this council shall have appellate jurisdiction over final decisions of the circuit courts, in certain cases, the Act operates as a negation or exception of such jurisdiction in other cases, and the repeal of the Act necessarily negates jurisdiction under it of these cases also. The repeal of such an Act, pending an appeal provided for by it, is not an exercise of judicial power by the legislature, no matter whether the repeal takes effect before or after argument of the appeal. The Act of the 27th of March, 1868, repealing that provision of the Act of the 5th of February, 1867, to amend the Judicial Act of 1789, which authorized appeals to this court from the decisions of the circuit courts in cases of habeas corpus, does not accept from the appellate jurisdiction of this court any cases but appeals under the Act of 1867. It does not affect the appellate jurisdiction which was previously exercised in cases of habeas corpus. The prisoner alleged an illegal imprisonment. The imprisonment was justified under certain acts of Congress. The question then presents a case arising under the laws of the United States, and, by the very words of the Constitution, the judicial power of the United States extends to it. By words of the Constitution, equally plain, that judicial power is vested in one Supreme Court. This court, then, has its jurisdiction directly from the Constitution, not from Congress. The jurisdiction being vested by the Constitution alone, Congress cannot abridge or take it away. The argument which would look to congressional legislation as a necessity to enable this court to exercise the judicial power, any and every judicial power, of the United States, renders a power, expressly given by the Constitution, liable to be made of no effect by the inaction of Congress. Suppose that Congress never made any exceptions or any regulations in the matter. What, under a supposition that Congress must define when, and where, and how the Supreme Court shall exercise it, becomes of this judicial power of the United States, so expressly by the Constitution given to this court? It would cease to exist. But this court is coexistent and coordinate with Congress and must be able to exercise the whole judicial power of the United States, though Congress passed no act on the subject. The Judiciary Act of 1789 has been frequently changed. Suppose it were repealed. Would the court lose, wholly or at all, the power to pass on every case to which the judicial power of the United States extended? This Act of March 27, 1868, does take away the whole appellate power of this court in cases of habeas corpus. Can such results be produced? We submit that they cannot, and this court, then, we further submit, may still go on and pronounce judgment on the merits, as it would have done, had not the Act of 27th March been passed. But however these general positions may be, the case may be rested on more special grounds. This case had been argued in this court fully. Passing then from the domain of the bar, it was delivered into the sacred hands of the judges, and was in the custody of the court. For aught that was known by Congress, it was passed upon and decided by them. Then comes, on the 27th of March, this Act of Congress. Its language is general, but, as was universally known, its purpose was specific. If Congress had specifically enacted that the Supreme Court of the United States shall publicly give judgment in the case of McCardle, already argued, and on which we anticipate that it will soon deliver judgment contrary to the views of the majority in Congress of what it ought to decide, its purpose to interfere specifically with and prevent the judgment in this very case would not have been more real or, as a fact, more universally known. Now, can Congress thus interfere with cases on which this high tribunal has passed or is passing judgment? Is not legislation by this an exercise by the Congress of judicial power? Lanier v. Galatas is much in point. There, a motion was made to dismiss an appeal because, by law, the return day was the fourth Monday in February, while in the case before the court, the transcript had been filed before that time, on the 15th of March. And while the case was under advisement, the legislature passed an act making the 20th of March a return day for the case, and a motion was now made to reinstate the case and hear it. The courts say, "The case has been submitted to us before the passage of that act and was beyond the legislative control. Our respect for the General Assembly and Executive forbids the inference that they had intended to instruct this court what to do or not to do whilst passing on the legal rights of parties in a special case already under advisement. The utmost that we can suppose is, in de Chasteau v. Fairchild, the legislature of Pennsylvania directed that a new trial should be granted in a case already decided. Gibson, C.J., in behalf of the court, resented the interference strongly. He said, "It has become the duty of the court to temporize no longer. The power to order new trials is judicial, but the power of the legislature is not judicial." In the State v. Fleming, where the legislature of Tennessee directed 2 persons under indictment to be discharged, the Supreme Court of the state, declaring that the legislature has no power to interfere with the administration of justice in the courts, treated the direction as void. In Lewis v. Webb, the Supreme Court of Maine declared that the legislature cannot dispense with any general law in favor of a particular case. Messrs. L. Trumbull and M. H. Carpenter, Contra. The Constitution gives to this court appellate jurisdiction in any case like the present one was, only with such exceptions and under such regulations as Congress makes. It is clear, then, that this court had no jurisdiction of this proceeding. An appeal from the Circuit Court, except under the Act of February 5, 1867, and so this court held on the motion to dismiss, made by us at the last term. The act conferring the jurisdiction having been repealed, this jurisdiction ceased, and the court had therefore no authority to pronounce any opinion or render any judgment in this cause. No court can do any act in any case without jurisdiction of the subject matter. It can make no difference at what point in the progress of a cause the jurisdiction ceases. After it has ceased, no judicial act can be performed. In Insurance Company v. Richt, the Chief Justice, delivering the opinion of the court, says, "It is clear that when the jurisdiction of a cause depends upon the statute, the repeal of the statute takes away the jurisdiction." And in that case, the repealing statute, which was passed during the pendency of the cause, was held to deprive the court of all further jurisdiction. The causes which were pending in this court against states were all dismissed by the amendment of the Constitution denying the jurisdiction, and no further proceedings were had in those causes. In Norris v. Crocker, this court affirmed and acted upon the same principle, and the exhaustive argument of the present Chief Justice, then at the bar, reported in that case, and the numerous authorities there cited, render any further argument or citation of cases unnecessary. The assumption that the Act of March, 1868, was aimed specially at this case is gratuitous and unwarrantable. Certainly, the language of the Act embraces all cases and all time, and its effect is just as broad as its language. The question of merits cannot now, therefore, be passed upon. The case must fall. The Chief Justice delivered the opinion of the court. The first question necessarily is that of jurisdiction, for if the Act of March 1868 takes away the jurisdiction defined by the Act of February 1867, it is useless, if not improper, to enter into any discussion of other questions. It is quite true, as was argued by the counsel for the petitioner, that the appellate jurisdiction of this court is not derived from acts of Congress. It is, strictly speaking, conferred by the Constitution. But it is conferred with such exceptions and under such regulations as Congress shall make. It is unnecessary to consider whether, if Congress had made no exceptions and no regulations, this court might not have exercised general appellate jurisdiction under rules prescribed by itself. For among the earliest acts of the first Congress, at its first session, was the Act of September 24, 1789, to establish the judicial courts of the United States. That act provided for the organization of this court and prescribed regulations for the exercise of its jurisdiction. The source of that jurisdiction and the limitations of it by the Constitution and by statute have been on several occasions subjects of consideration here. In the case of Durousseau v. the United States, particularly, the whole matter was carefully examined, and the court held that while the appellate powers of this court are not given by the Judicial Act, but are given by the Constitution, they are nevertheless limited and regulated by that act, and by other such acts as have been passed on the subject. The court said, further, that the Judicial Act was an exercise of the power given by the Constitution to Congress of making exceptions to the appellate jurisdiction of the Supreme Court. They have been described affirmatively, said the court. Its jurisdiction and this affirmative description has been understood to imply a negation of the exercise of such appellate power as is not comprehended within it. The principle that the affirmation of appellate jurisdiction implies the negation of all such jurisdiction not affirmed having been thus established, it was an almost necessary consequence that acts of Congress, providing for the exercise of jurisdiction, should come to be spoken of as acts granting jurisdiction, and not as acts making exceptions to the constitutional grant of it. The exception to appellate jurisdiction in the case before us, however, is not an inference from the affirmation of other appellate jurisdiction. It is made in terms. The provision of the Act of 1867 affirming the appellate jurisdiction of this court in cases of habeas corpus is expressly repealed. It is hardly possible to imagine a plainer instance of positive exception. We are not at liberty to inquire into the motives of the legislature. We can only examine into its power under the Constitution, and the power to make exceptions to the appellate jurisdiction of this court is given by express words. What then is the effect of the repealing act upon the case before us? We cannot doubt as to this. Without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. And this is not less clear upon authority than upon principle. Several cases were cited by the counsel for the petitioner in support of the position that jurisdiction of this case is not affected by the repealing act, but none of them, in our judgment, afford any support to it. They are all cases of the exercise of judicial power by the legislature or of legislative interference with courts in the exercising of continuing jurisdiction. On the other hand, the general rule supported by the best elementary writers is that, when an act of the legislature is repealed, it must be considered, except as to transactions past and closed, as if it never existed. And the effect of repealing acts upon suits under acts repealed has been determined by the adjudications of this court. The subject was fully considered in Norris v. Crocker and more recently in Insurance Company v. Rich. In both of these cases, it was held that no judgment could be rendered in a suit after the repeal of the act under which it was brought and prosecuted. It is quite clear, therefore, that this court cannot proceed to pronounce judgment in this case, for it has no longer jurisdiction of the appeal, and judicial duty is not less fitly performed by declining ungranted jurisdiction than in exercising firmly that which the Constitution and the laws confer. Counsel seem to have supposed, if effect be given to the repealing act in question, that the whole appellate power of the court, in cases of habeas corpus, is denied. But this is an error. The Act of 1868 does not accept from that jurisdiction any cases but appeals from circuit courts under the Act of 1867. It does not affect the jurisdiction which was previously exercised. The appeal of the petitioner in this case must be dismissed for want of jurisdiction. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.